Every day in the USA, people find themselves in court.
We will go on the record in the matter 25 CF 22, State of Wisconsin versus Michael Denn. The state appears through Assistant District Attorney Holly Rockow in person. We have Glenn Keene, Defense Counsel, appearing by video conferencing. We have Michael Denn also appearing by video in custody in Burnett County Jail. We're set here today in the matter for an initial appearance. Mr. Keene, were you able to go over the criminal complaint with Mr. Den?
Yes, Your Honor. Reviewed the charges, ranges of potential penalties. Mr. Den would waive reading, plead not guilty to the misdemeanor, and ask to have an arraignment. Oh, we're also going to ask for a bond reduction motion at some point in the near future, but I have not yet filed that.
Okay, sounds good. So he's entitled to a preliminary hearing. Is he asking for that within time limits?
Your Honor, Mr. Den is going to waive the preliminary hearing.
Oh, he wishes to waive it outright?
Yes.
And does he wish to do that now and then set the matter for a bond modification hearing in short course?
Yes, Your Honor.
Okay. We can set it for March 4th at 2:15. March 4th at 2:15. Does that work for your calendar, Mr. Keene?
Yes, Your Honor, because I'm there anyway that afternoon.
Oh, that's right. You are. So March 4th at 2:15. Okay, we'll see you then.
Take care.
Thank you. We will go on the record. This is Mr. Den. What are you looking for?
Oh, sorry, there was just a bunch of other things.
We will go on the record in the matter 25 CF 22, State of Wisconsin versus Michael Den. The state appears through District Attorney Kevin Schmidt in person. We have Glenn Keene appearing in person. Mr. Den appears by video conferencing in custody in Burnett County Jail. We're set here today for a request for a bond modification. Mr. Keene has filed a bond modification request on February 25th. Mr. Keene, please provide argument for the record.
Yes, Your Honor. As the court's well aware, before trial, there's a presumption that a defendant has a right to be out, not in custody and preemptively punished unless there's reason to believe that the defendant will not show up for court.
That's not necessarily true, and the state just has to prove that there's probable cause to believe that the crime was actually committed in order for the court to assess bail and to use other certain factors. It's not just making assurances that they're coming to court.
He's been in custody for, a month and a half, pretty much, is not being able to raise the $100,000 bond. And the only reason he didn't qualify for a public defender is because he did have, some property in the county. And we're requesting to lower bond to $5,000 secured by his property. And I do have a copy of the deed that I could file with the court, but the properties are valued at $33,000 because they're together $33,400 for as far as property tax valuation.
Mr. Schmidt?
I would oppose modifying bond at all. I'm deeply concerned that if Michael Den's bail is reduced any amount, he might be able to get somebody with a lot of money to post it for him, somebody powerful he knows through his connections or his family. He's charged with a delivery, which was a controlled buy, so that's a strong evidence, and he was found with nearly 100 grams of methamphetamine. The evidence is strong in the case. The strength of the evidence is something the court considers in determining bond because that's mandated by statute. He admitted to law enforcement that he was acquiring methamphetamine in the quantities of, in his description, pounds and kilos and bringing them to Burnett County and distributing them. He said his connections are in the cities, which is where his main connection is from. He only came here from Minnesota in around 10 years ago, and he's been at that property he's describing. With his admissions and what he has there, that's strong evidence. In his interview with Deputy Mogen, he expressed fear that he was going to die in custody because of these charges, which is more concern for the court that he might not come in the future. It is true that he has generally made court appearances on bond, both here in Minnesota. He has not necessarily followed probation conditions. The 2018 case we had in Burnett County, for example, was while he was on probation for felon in possession of firearm out of Minnesota. He has some familiarity with the sentencing on these charges, not just from the maximum penalty. Mr. Denn's twice been convicted before for crimes related to the sale of drugs. The first time he only got a year in Minnesota. The second time he got a 10-year sentence. I think he rightly fears that he might get more than 10 years, and with his age, that could wind up basically being his whole life. I think with the strength of the evidence, with his history, with his demographic information, I think the court shouldn't reduce bond. If he gets out, I don't think he's coming back.
All right, well, like I said, I think when you look at it, you do have to at least consider, his past performance as far as court appearances.
I did, but
Right.
that's low-end felonies to maximum of 40 years of incarceration is what he's facing for one, maximum of 12 and a half for another, and then 3.5 for the maintained drug trafficking place.
Right.
Those are two very serious felonies, one serious because it's a felony. So the court denies bond modification.
All right, I've also been, Mr. Den wishes to invoke his right to a speedy trial as well. And I filed the motion for discovery from the DA's office.
All right, so Speedy, put it in writing, but we can get a trial date set. Mr. Schmidt, how many days do you think we're going to need?
Honestly, probably one.
Only one day?
It was one control by and then searching, playing his interview, no, 2 days.
All right. We will go on the record in the matter 25 CF 22, State of Wisconsin versus Michael Denn. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Den appearing in person in custody with counsel Glenn Keene. We're set today in this matter for a final pretrial. The court's drop dead date as to any agreement to be reached. The parties have reached an agreement. Mr. Keene, can you please recite the agreement for the record?
Yes, Your Honor. The agreement calls for Mr. Den to plead guilty to count 5 with all other counts dismissed and read in. We're both calling for a PSI with the state restricted to the PSI cap with defense free to argue.
All right. Mr. Den, that is the agreement that you have reached with the state?
Yes,
Oh,
Your Honor.
so I have in front of me a plea questionnaire, waiver of rights form. Do you recognize this document?
Yes,
Did your attorney go over this document with you?
yes,
Did he go over it thoroughly with you?
yes,
Essentially word for word?
yes,
You understand everything on that document?
yes,
If you didn't understand something, did your attorney explain it to you until you did?
yes,
And attached to that document is the jury instructions for possession of a controlled substance with intent to deliver with lesser included offense of a possession of a controlled substance. Did your attorney go over that with you?
yes,
And you understand that?
yes,
And he explained it to you thoroughly.
yes,
You are pleading guilty to one count. That would be count 5, possession with intent, methamphetamine greater than 10 grams, but less than 50 grams, a class D felony. Is that correct?
yes,
You are 63 years old. You have 12 years of schooling. You can read, write, and you understand the English language. Is that correct?
yes,
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
yes,
Did your attorney go over with you the maximum possible penalties that you face?
yes,
You are not receiving treatment for a mental illness or disorder, but you have had some type of medication in the last 24 hours?
yes.
What type of medications?
I'm not for sure for diabetes.
Just diabetes?
Yes,
And those medications don't interfere with your ability to comprehend or understand?
no, they do not.
Okay. Other than that, no alcohol, medications, or other drugs?
No,
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on this document. Did your attorney thoroughly go over those rights with you?
Yes.
Do you understand them completely?
Yes.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that you'll no longer have the right to a trial?
Yes.
You'll no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify or remain silent and not have your silence used against you. You will no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. You would also no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up here today?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm or have a concealed knife, which would include a pocket knife, for life.
Yes.
Do you understand that you would not be able to vote in any election until your civil rights are restored?
Yes.
Do you understand here that the state would have to prove on or around January 24th, 2025 in Burnett County, Wisconsin, that, give me 1 second, in Burnett County, Wisconsin, that you did possess with the intent to deliver a controlled substance, to wit, methamphetamine, in an amount of more than 10 grams, but not more than 50 grams, contrary to Wisconsin law, a Class D felony. Do you understand what the state would have to prove?
Yes.
Do you understand that upon conviction, you face a fine of not more than $100,000 or imprisonment of not more than 25 years of incarceration, or both?
Yes.
Do you understand that there's an agreement that's been reached between the parties in which the court would order a pre-sentence investigation report, and the state would be capped at the recommendation for sentencing in that report? Do you understand that?
Yes.
Do you understand what that PSI report is?
Yes.
And that document will have a whole lot of information about you and about your life, and it will provide a recommendation from the Department of Corrections standpoint as to sentencing. Do you understand that I'm not bound to follow that recommendation?
Yes.
Do you understand I'm not bound to follow the recommendation and argument of the state?
Yes.
And I'm not bound to follow the argument and recommendation of the defense when defense is free to argue. Do you understand that?
Yes.
Do you understand that it would be my discretion to sentence based upon the facts that I have, and it could be up to the maximum possible penalty?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did you go over the criminal complaint with your attorney?
Yes.
In particular, there is a section called the probable cause section, which basically says what happened that day and why you were charged with the crimes. Do you remember that?
Yes.
He is showing you a copy of the electronic criminal complaint right now. For the most part, are those facts, are they accurate?
Yes.
Are you admitting here today that you in fact did possess with the intent to deliver methamphetamine,
Yes.
and it was greater than 10 grams, but not more than 50 grams?
Yes.
And so you're admitting here to having the guilt with possession of intent to deliver methamphetamine.
Yes.
Mr. Keen, may the court use the probable cause of the criminal complaint along with the statements made by your client to find a factual basis.
Yes, Your Honor.
Has anyone made any threats or any promises to you, Mr. Den, for you to plead guilty to this charge?
No.
You're doing so freely and intelligently. That means you understand
Yes.
what you're doing here today
Yes, Your Honor.
voluntarily?
Yes, Your Honor.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Are you satisfied with his services?
Yes.
Do you have any questions for the court or for your attorney before I proceed?
No, thank you.
Mr. Keen, do you believe that your attorney is entering his plea freely, intelligently, and voluntarily
Yes, Your Honor.
with a full understanding of his constitutional rights and what he would be waiving?
Yes, Your Honor.
Do you believe he's entering his plea competently?
Yes, Your Honor.
Did you thoroughly go over what the state would have to prove, those elements with the facts of the case from the discovery?
Yes, Your Honor.
And did you go over the strengths and the weaknesses of the case with your client?
Yes, Your Honor.
Mr. Den, do you believe that your attorney went over with you whether or not you have any defenses or a lack of defenses in this case?
Yes.
Are you satisfied with his services?
Yes.
One last time, do you have any questions for the court or for your attorney before I proceed?
No. Thank you.
As to count 5, possession with intent to deliver methamphetamine greater than 10 grams, but less than 50 grams, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I will find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 5. The remaining counts will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Mr. Den, on the second page of the plea questionnaire waiver of rights, is that your signature?
Yes.
The court will order a pre-sentence investigation report, long form. Agent does not need to appear, but should be readily available if questions arise. The court will now revoke bond and will set the matter for sentencing. I can do July 29th at 1.
That works for the defense, Your Honor.
Okay. We'll see you July 29th at 1 o'clock.
Right now.
Right now, we have.
We are adjourned.
No.
Okay.
Okay.
Talk to you.
Yep.
I can't hear you when you're
Right.
whispering.
Yeah. Okay.
We're done?
Yep.
Thank you, Your Honor.
Thank you, Mr.
You have a
Dunn.
great day.